So can we start?
Proceed.
A very good morning to your lordship. Is your lordship well versed with the facts of the case?
Yes, proceed.
Okay. So your lordship, we approach your honorable court raising two issues as our main contentions. Our first issue is going to be divided into four further sub-issues.
Before you
And
start on the issues, counsel, on what
yes,
under what provision are you approaching this court?
your lordship, two. Wait, yeah. Your lordship,
What are you?
your lordship, you're approaching this court under the jurisdictions of Article 32 and 136 of the Constitution.
Article 32 and 136.
Yes, your lordship.
So is this a writ petition or a special leave petition, or what petition is this?
It's a culmination of both, because the matter.
Are you sure that can be done, counsel?
Yes, your lordship, according to
file two different kinds of petitions in one petition.
Your lordship, it's the Supreme Court that exercised its own extraordinary powers and clubbed the two matters, as the facts of the case state.
So you are saying that there are two different.
Court itself did it.
You are saying that there are two different cases which have been clubbed in one. Is that so?
Yes, sir. Yes, sir.
Okay. What were the facts of the first case? Mane, what was just give me a brief rundown of the two different cases. Brief, 5 seconds only.
Yes, your lordship, in the first case, Mrs. Soumya approached the police station claiming that the person she had married to had eventually turned out to be one who practiced atheism and not what he had claimed to be, like, as he claimed to be practicing Veronism. And then there was, and then
so there was a criminal case against somebody, and that person applied for bail, and he also filed a.
It was rejected. Petition. Yes, sir. Yes, sir. Okay. And he filed a writ petition challenging the Constitution. Yeah. So your lordship, the first issue that we are raising right now is whether the Georgetown Freedom of Religion Act is ultra vires of the Constitution and challenging its constitutional validity. And the second issue that we are raising is whether the petitioner, that is Rana alias Mana, is entitled to be released on bail.
Okay.
Your lordship, with your permission, I'd like to proceed with the first issue.
Yes, sure.
To tell you that the Freedom of Religion
Are you sure you want to prioritize the issues in that manner? Are you sure you don't want to argue for bail first and then argue for constitutional validity? Because constitutional validity is a longer process. I might not decide on the constitutional validity right away. I might release your client on bail first.
Your lordship, we think that it's really important because our client in this case is also worried about the implications that this act has on, like, the different people.
Yes, but you as a lawyer should decide what is more important, the constitutional validity challenge or the bail of your client. Who's paying you your fees, counsel?
Your lordship, what we were trying to say is, I think we'll be trying to.
The thing is, because frankly speaking, if I decide that the thing is not constitutionally valid, automatically your client will get bail. So might as well argue the bail first and then argue the constitutional validity.
Your lordship, my co-counsel will be arguing bail with equal weightage, which is why we've divided the time equally amongst ourselves. So we will be.
Why don't you have your co-counsel go first and you go second? What's the problem with that?
Your lordship, this is how we decided it. And,
I'm trying to understand what made you choose this order of prioritization. Why did you choose to first speak about constitutional validity and second about the bail?
We just proceeded with the issues that the order in which they were essentially mentioned in the moot court problem itself. So we just chose to go ahead with that.
Oh, you basically went along with what the brief told you.
Yeah. Yes, sir. We did.
Sometimes you need to think beyond the brief and apply your own mind, counsel.
Yes, sir. We agree to that, but we think that
okay, fine. Go on, proceed.
Yes. Your lordship, we think that this act claims to prohibit unlawful conversion by misrepresentation, force, undue influence, but we don't think that is what this act in reality does, especially with its application, because what it actually facilitates. Sorry.
Why do you think so, counsel? Why do you think it does?
I was just coming to that, your lordship. We think that this act actually facilitates parties to be injured and second-guess decisions of consenting adults, because according to us, we think that religion and marriage both are exceptionally sacred and intimate choices. So when you have the state intervening into such choices of consenting adults, we think it's a huge problem.
Tell something. Is this the only instance where the state intervenes in the choices of consenting adults? Does the state never intervene otherwise?
I'm sure it does, Your Lordship. I'm sure it does.
So what is the particular flaw with regard to this particular law where it is so heinous that we cannot intervene?
Your Lordship, if you will just, I would like to proceed with it because it's incorporated in my speech. Like I will be explaining it over.
Counsel, I am not here to. I'm not here to hear your speech. I'm here to hear legal arguments. Get to the legal
arguments. Your Lordship. The arguments that we're going to.
I'm not going according to your script. I'm going according to the court script.
Yes, Your Lordship. We're just going to go ahead with what we've prepared. But before we go into our own arguments, what we also want to preemptively do is prevent the respondent from coming and telling this court that this judgment is constitutionally valid with reference to the landmark judgment of Reverend Stanislaus versus State of Madhya Pradesh and others, 1968.
What is the principle of that judgment that you're citing?
Your Lordship, what we are trying to preemptively tell you that when
what is the ratio of the judgment you're citing?
Yes, Your Lordship, the ratio, it declared the Madhya Pradesh Dharma Swatantrata Adhyan or Act of 1968 to be constitutionally valid. But we do not think that that is something that the respondent can come and cite in today's matter, because if you would just look at Article 17(1) of the section.
Are you citing that judgment? Are you citing that judgment that you just mentioned, Stanislaus versus whatever?
Your Lordship, we exchanged memorials. So what I'm doing is I'm preemptively trying to rebut whatever. Like
you first get to your own case before preemptively rebutting. You don't preemptively rebut. Get to your own case first.
Sure.
What is your case, counsel?
Yes, sir. So the first sub-issue that we raise is how this act violates Article 21. Because Section 3(1) of this act says that no person shall A, convert or attempt to convert either directly or otherwise any other person by the use of misrepresentation, allurement, use of threat, force, undue influence, coercion, and this is where the keyword is, according to us, Your Lordship, marriage, or by any other fraudulent means. We think that this section is legally unsound because it suggests that anybody who converts for the sake of marriage makes such conversion, because this section makes
that counsel is counsel that has been established in judgments before, that conversion solely for the purpose of marriage is not a valid conversion, even before this bill came about.
Your Lordship, that is.
Are you aware of such judgments?
I am just aware of the Stanislaus case, Your Lordship.
You're not aware of other judgments in this regard?
No, Your Lordship. I'm plead your.
Have you heard of this, the case of, anyway, so you're not aware of any other judgments, right, on this point? Sallah Mudgal versus Union of India, have you considered?
We have that eventually in our scripts. Yes, sir.
So when you have considered Sallah Mudgal, can you tell me that why particularly you say that in the case of marriage, this is not valid, when especially when before this law came about, the Supreme Court has already held that this thing, that conversion for the purpose of marriage is not valid, just for the purpose of marriage.
Yeah, Your Lordship, we think that this is an extremely draconian form of a law, because we think that marriage is an extremely intimate and personal choice. We were going to refer to judgments of Shafin.
Yes, but then if you're just marrying for the sake of circumventing other processes, then it's something that obviously is constitutionally invalid. It's not valid.
Your Lordship, we don't think that is the basis of marriage.
If you wish to circumvent punishment for bigamy by converting to Islam, is that justified, counsel, according to you?
Your Lordship, I don't think I'm in a position to comment on somebody's personal choice, because
I'm asking a hypothetical situation, not a personal choice. I'm saying, let's say a Hindu man is already married, but he wants to marry again, and he doesn't want to go through the messy process of divorce. He just converts to Islam and says that under Islam, I am allowed more than one wife, therefore I cannot be considered a bigamist.
Your Lordship, I think that as much as it pains me to say this, but I think that's legally justified, even though morally not.
Isn't that directly, what your submission is directly in the face of Sallah Mudgal, counsel? What is the are you aware of the ratio of Sarla Mudgal versus Union of India?
Your lordship, my co-counsel will refer to Sarla Mudgal because he has studied that case in a better way. So I think
your co-counsel knows it, but you don't know it.
Your lordship, we divided the issues that way. So he has genuinely prepared with Sarla Mudgal. So I think he'll be able to address it better. So
Counsel, your lordship, is that not good preparation, counsel? Because Sarla Mudgal is a constitutional point. Your co-counsel is dealing with bail. And here you are telling me that
he is dealing with the
point, you don't know the judgment. That reflects very poorly, counsel.
Your lordship, he will be dealing with constitutional validity as well. He is going to be taking on a sub-issue. So
you started off by saying your co-counsel will be dealing with the bail part and you will be dealing with the constitutional part. How have you divided the issues, counsel?
Your lordship, we have 4 sub-issues under constitutional validity, and the first 3 sub-issues will be dealt by me. And the last sub-issue and the
division of issues. I'm very sorry to say. I'm very sorry.
I understand. We apologize for the ignorance and.
All right, fine. Proceed.
Your lordship, we would like to refer to Shafeen Jahan and Ashok Khem, where the Supreme Court established that the right to marry a person of choice as an important facet of Article 21, emphasizing that matters of faith form the core of constitutional values, which is also something that we are going to now show you in terms of our compendium, where we refer to the landmark judgment of Shakti Vahini versus Union of India. It's a recent judgment. It's on page 7.
Before you start off with your citation of all those judgments, I just want to understand from you, does this law prevent all conversions where the person is converting before marriage, or does it prevent certain types of conversion before marriage?
We think that it criminalizes the most essential form of conversion that we are arguing before your honorable court, your lordship, which is conversion that is done before marriage. And we think that that's really antithetical and like problematic.
In all cases where where somebody converts prior to getting married, this law criminalizes that?
Yes, your lordship.
There is no exception provided.
This law criminalizes the fact that anybody has converted for the sake of marriage, which is as mentioned in section 3(1) of this act.
For the sake of marriage, but if a person can show that I have genuinely switched over to this faith, then he won't be criminalized.
Yes, your lordship, but it still puts jeopardy, and we are going to refer to why that jeopardy becomes so pertinent.
You understand why my thought process here. My thought process here is that if you are converting just for the sake of getting married to somebody, then that's not a genuine conversion in the first place. That is a fraud upon the law. It's a fraud upon the religion as well. Don't you agree?
Your lordship, we think the way this act mandates the whole thing is problematic, and we were just going to go ahead with that on 2 grounds.
Yeah, go ahead with that. Go on to that particular thing.
Yes, your lordship, we think that
the mandate.
So your lordship, this is a procedural law which establishes that if anybody wishes to convert in such case, they need to give a 2-month advance notice to the district magistrate. That is our first contention. And the second contention that we have a problem with, your lordship, is the locus standi of somebody approaching the police, which is the police goes into investigation against the accused on a written complaint from the parents or someone of the family of the alleged aggrieved party.
Before you start off on the second prong, do you have a problem with the 2 months advance notice?
Yes, your lordship, we do. Yes, your lordship.
Why?
Your lordship, because I think at this point we are going to argue this on the basis of the status quo that we are currently living in, because it's established in the facts of the case that the Georgetown Democratic Party came into power in 2020 on the pretext of saying that it is going to restore the respect of the majoritarian Viram community. And we think that
you are reading into the intention of the legislature. You cannot read into the intent that way.
Your lordship, we think it's just a reasonable inference that we are making here.
It's not a reasonable inference. Just because they asked for advance notice, that doesn't mean it's necessarily a result of bigotry. Bigotry should not be read into a statute unless it is absolutely apparent on the face of it.
Your lordship, we also would like to bring to your notice that when somebody submits to the district magistrate in terms of their will to convert, the magistrate must satisfy themselves whether such conversion is lawful or not. And we think that, like I'm just quoting you, sir, that religion itself is an extremely intimate and personal choice. It's the relationship that exists, as cited in previous judgments. It's a relationship between this person and God. And we do not think that the state should essentially have a power to decide
here
whether
the
such
magistrate is saying, magistrate is merely seeing whether the belief is genuine or is it just a sham.
Your Lordship, we humbly contend in front of you that we don't think that there is anybody present who should have a say in the genuineness of someone's belief. We think that
you're saying that there's too much discretion in the hands of a magistrate.
Yes, sir. Yes, sir. Yes, sir.
Do you have any judicial, any judgments to support the fact that there should be limited discretion in the hands of government officials?
Yes, Your Lordship. I think we do. Yeah. Yes, Your Lordship. Which is the chilling effect case. Your Lordship, if you just give us a second, I'd refer to my notes and
take your time.
Yes. The chilling effect case that we gave you. Yes, Your Lordship, we would like to refer to SR Bommai versus Union of India, which is on page 31 of our compendium and page 95 of the judgment.
I'm aware of SR Bommai.
Yes, Your Lordship, and I'm quoting SR Bommai here, which states that introduction of politics into religion is not merely a negation of constitutional mandates, but also a positive violation of constitutional obligation, responsibility, and prescription of prohibition specifically enjoyed by the Constitution. Your Lordship, we think that when it's something has
is this in your compilation?
Yes, Your Lordship, it is.
Which part?
Yeah, it's on page 31. Which part? This section is in sorry?
Here.
Yes, Your Lordship, if you can just refer to para number 190, the third line.
Okay. All right, fine. No problem.
Yes. Your Lordship, the other contention that we have that is essentially very problematic is that this section offers, which is where the family of an alleged aggrieved person may approach the police, and the police are going to start into an investigation on a written complaint. But we also contend that one of the biggest problems this now has is placing a reverse onus on the accused to prove himself to be innocent, which is a direct violation of what our justice system essentially stood
on. But wait, just hold on one second.
Yes, sir. Yes,
with regard to the second part of your contention, that that the onus is shifted to the accused, I can understand that how that is problematic, and even I am sympathetic to you there. But with regard to allowing the aggrieved family members to approach the police, I don't see where the problem lies. Who else will raise the complaint?
Your Lordship, Your Lordship, look at status quo. I think we need to analyze status quo right now, because we think that this becomes a huge problem because of the existence of disapproving parents. We think that there still exists that draconian thought that your parent should choose your partner, and that your parent
undoubtedly, I'm not denying that one bit. But then if you take away the power of the parents, disapproving parents, to approach law enforcement, who else will approach law enforcement? In case, I'm assuming, but all that you're saying is true. But in case there is a genuine case where somebody has been coerced into changing religion in order to marry someone, and the aggrieved family members have know this person has been coerced, where will they approach? Who else will approach?
Your Lordship, we don't have a problem with that. What we have a problem is that it simply starts at the behest of a written complaint, and then it places the wrong burden on the accused to be able to defend himself.
I am once again, you're not understanding what I'm saying. I have no problem with what your argument on onus shifting. Onus shifting is wrong. This is completely contrary to principles established criminal jurisprudence. But
yes,
what is your problem with having family members approach the law enforcement? Do you have a problem with that, or that is not a problem?
Yes, Your Lordship, we do have a problem with that.
Then
because
who
we
will
think
approach
that
law enforcement if the family members don't approach?
Your
If
Lordship,
in case, see, the thing is, where I have an issue with what you're arguing is that you have no problem with I mean, you have problem with the family members approaching, because then in genuine cases where there is coercion and threat, where who is supposed to take the lead?
Your Lordship, we agree that that is a problem, but we also think that the moment you allow all members that are related by blood as well, which is related in locus standi, we think that there is going to be a huge influx of fake cases, and it's not just going to be problematic towards the accused, but also take up a lot of the court's
just because there are fake cases, do we throw out the baby with the bathwater? There are false rape allegations all the time. Do we do away with the provision of
No,
rape?
Your Lord.
Then,
Your Lordship, that is not what we are trying to contend.
That is precisely what you're arguing. We are arguing that there will be a huge influx of false allegations. Therefore, we should do away with the provision altogether.
Your Lordship,
is that not what you're suggesting?
Your Lordship, what we are trying to suggest is the pertinence of the reverse of the onus of burden, and that is the problem.
That I am in accordance with you. But where is the problem with the locus standi?
Your Lordship, locus standi with reference to the burden, right? Because now whenever anybody is approaching the court,
so Your Lordship, if the court, for instance, rules that the onus shifting is unconstitutional, but the locus standi is not a problem, will you accept that?
No. Yes, Your Lordship, we will accept that. We will be okay with that.
Very reasonable, you counsel, but your time is up, so I think we'll have to move to your co-counsel, I suppose.
Yeah, for bail. Sure, sir. Thank you so much, sir.
No problem. Just before your co-counsel starts, just give me a little about 5 minutes, about 2 minutes. Sorry.
Yes, Your Lordship.
Okay. Yeah, co-counsel, you can start.
Lordship, I would like to proceed with the arguments regarding bail. Your Lordship, it's very, very important before we analyze bail, we need to understand the last subtopic, which was the burden of proof, which Your Lordship has already agreed upon. We believe when this burden of proof is pushed on to the accused, it makes the entire purpose of this criminal law very, very questionable, right? We believe the presumption of innocence in itself is a golden thread running through criminal law, and when you shift that, it becomes very, very difficult for the entire.
Where was this first described as the golden thread running across criminal law? Do you have any idea?
Sorry, Your Lordship, we don't know that.
Do you have any idea as to how this concept of golden thread running through criminal jurisprudence came about? Do you have any context?
Yes, sorry,
where did you come across this? This is not your original thought, I'm sorry to say.
Yeah, Your Lordship. It was. I came across this in the book by D.D. Basu. So I read it in a book.
Very good. Continue.
So, Your Lordship, we believe that it's very, very important to analyze this aspect as well. And a landmark judgment in that case would be the Justice Indu Malhotra saying in the Joseph Shine versus Union of India, where she says the element of public censure visiting the delinquent with penal consequences and overriding individual rights would be justified only and only when the society is directly impacted by such conduct. In fact, a much stronger justification is required where an offense is punishable with imprisonment. the state must follow the minimalist approach in the criminalization of offences, keeping in view the respect for the autonomy of the individual to make his or her personal choices.
Okay.
This, Your Lordship, is very, very important right now, because we believe that the state has gone overboard in criminalizing an offence. Because we believe there are already certain laws in place which criminalize this offence. The conversion of marriage, the conversion for the sake of marriage, it's being dealt with marriage laws, and it can also be found in the GPC under cheating as well. But we believe this new ordinance serves no purpose other than being used as a mere tool for harassing interfaith couples.
But tell me something, is there any difference in the penalty provisions under this law and the penalty provisions in other existing laws?
Yes, Your Lordship. Even in the landmark case of the Senate's laws, it was they had no provisions for annulling marriages. Their conversion was a bailable offence with a maximum sentence of 2 years. Here we have this has been made a non-bailable offence. This has been the extent to which the imprisonment may extend is up to 5 years, which will also be liable to a fine. Also, in certain cases, it shall be not less than 2 years, but which may extend to 10 years as well. So, Your Lordship, we believe this is an unnecessary move by the legislation to make
go ahead and make sure that are these provisions harsher than existing provisions on this kind of thing? So that answers your question. That is the need of this law.
Your Lordship,
the existing laws have obviously not been effective in preventing these kind of coerced conversions. Therefore, this law has been enacted to be more effective.
Your Lordship, we on the contrary believe that the existing laws are very much capable of preventing these menaces. This is just
the fact is they haven't. The fact remains that conversions for coerced conversions continue, which is why this law has been brought.
Your Lordship, this law, one important factor to note as well is after this law came into place, there has been record statements where people have said that there is an increase in number of fake cases, which we believe that this law is just being misused, and the previous laws were pretty much well equipped to handle with these kind of situations.
So are you saying there were no fake cases brought about under the previous existing laws?
Yes, Your Lordship, there were, but the number of cases have been rapidly increased after this law came into place. And that is why we refer to Joseph Stein versus Union of India, where Justice Indhu Malhotra herself has said that the state must follow the minimalist approach in the criminalization of offences. So we believe that this is an important factor that needs to be into consideration. And assuming that this law, like if this law is constitutional, and then we go on to the bail aspect of the entirety of for our petitioner, we believe that there's a recent case of Munna Khan versus State of UP, where the court says that it is but obvious that the applicant and the victim were in a relationship from the last 4 years, and there was no ordinance, and also there was no objection or resistance from the side of the victim. All of a sudden, after bringing this ordinance into existence, she became aware of her rights and exposes her conduct. Full and active participation.
Counsel, just one question. By her being the last one. Counsel.
Yes.
Can you hear me? Can you hear me?
Yes, Your Lordship.
Yeah. No, yes, in this case, who complained against your client?
The wife, Mrs. Sandra, has filed a complaint after being in a relationship for 4 months. So direct parallel can be drawn.
4 months. That's not a long period. That's not a long period. Here, the case you're citing is of 4 years, and this is 4 months. Much shorter time frame.
Your Lordship, we believe,
and this is not the family of your wife which is objecting. It's your wife itself has objected. So therefore, there is some validity to the allegations against you.
We believe that, Your Lordship, that this Mrs. Sandra was being a capable woman and not a minor. It's very hard because the petitioner itself has said time and time again that she was well aware of the petitioner's religion and that she chose to convert out of her own free will. We believe that it's
before marriage.
Yes, Your Lordship. It's in the moot problem. It's been written that the petitioner has said that the wife converted out of her own will, and that she was well aware of the fact that this person did not practice the religion of atheism.
Yeah, but then
and it's also very important that they're citizens of the same town.
This is something that your petitioner is claiming.
Yes, Your Lordship.
But just because your petitioner is claiming it doesn't mean it's not, it is true, right? Your client will say any number of things. That doesn't mean it's right, correct?
Yes, Your Lordship, but we also believe that
how
the
do
fact
you know?
they were
How do we know that your
geographically
client had not been exerting mental pressure on this person to convert?
Your Lordship, because the fact that they were living in a geographical proximity, because they were residents of the same state, same city as well, it's very, very difficult for us to acknowledge the fact that the respondent here, or Mrs. Sandra, was not aware of the religion of the
I'm
petitioner.
not saying they're not aware, but the point is that this is something that has been coerced. She has been coerced by you.
Your Lordship, it's also
the
very important to
has
note that
exerted mental physical mental pressure and coerced her into changing her religion.
Your Lordship, even if we say that, it's also very important to note that their marriage was a public event in front of the relatives and in front of all these relatives of both the families. So we believe that must be taken into account, where the petitioner says that all of them were well aware of the fact that the petitioner practiced a different religion, what he's being accused of.
So the petitioner, your wife's family was very accepting and very liberal. That doesn't mean that you haven't exerted coercion upon her.
Your Lordship, that is where we bring in the next point, even if this goes on to say that the petitioner did use such measures, he is entitled to bail. Because we believe again that the fact, if we refer to Motiram at the state of MP, because this is a case where the burden of proof is.
How long has your client been in jail, counsel?
Pardon me.
How long has your client been in custody?
1 second, Your Lordship. He has been in custody for 3 months, Your Lordship.
Only 3 months. 3 months, may you are saying that you're already saying that it's too long.
Your Lordship, we are not saying that it is. We indeed believe that it's too long, because here
has charge sheet been filed in the case, counsel?
Detention.
Has charge sheet been filed in the case?
Yes, Your Lordship.
So charge sheet has been filed, and you applied for bail before the lower courts and it was rejected.
Yes, Your Lordship. The High Court did reject the bail.
So that I'm personally speaking not satisfied with your bail application, counsel.
Your Lordship, this is where we like.
You are dealing with the constitutional point as well, right?
Yes, the last one, which was the burden of proof, and which is what we combine with the bail application, and we say that the consequences of pre-trial detention are graver. Defendants presumed innocent are subjected to the psychological and physical deprivations of jail life.
Even in cases where the burden of proof is not shifted, at the bail stage we only look at prima facie case. We don't look at the presumption of innocence then.
Yes, we do agree to that, Your Lordship, and we believe that prima facie the entirety of the allegations that Ms. Sandra is putting on the petitioner is very frivolous in nature. Because
counsel, counsel had mentioned that you were supposed to cite Salla Mudgal. Are you aware of Salla Mudgal versus Union of India?
Yes, Your Lordship.
And what does that case say, counsel?
Just a moment, Your Lordship. Just like looking for it. With Your Lordship permissions, if we could read that in the rebuttal, because the time is up and we have 2 minutes for rebuttal as well.
No, don't worry about the time. I am in charge of time. You just cite Salla Mudgal. I want to hear from you about Salla Mudgal.
Yes, Your Lordship. Just a moment. Responded.
You're obviously not prepared with Salla Mudgal. Okay, never mind. You can.
Your Lordship, it will just take 1 moment.
I've heard you. Finished. Okay.
Your Lordship, Your Lordship, before we begin, we would like to cite the prayer as well.
I'm aware. There's no problem. Okay, we'll move on to the other side. Respondent.
Sorry, Your Lordship, to interrupt. Please, everyone, enable your video feed. Thank you.
We'll move on to the respondents now, right?
Yes, Your Lordship.
Yeah.
Good morning, Your Lordship. And my one minute, Your Lordship.
Yeah, you're very faint. I can barely hear you.
Am I audible, Your Lordship?
Yes, now you're audible.
All right. Good morning, Your Lordship, and my fellow learned counsels in opposition. We are from the side of the respondent. I will be arguing the matter of constitutionality, and my co-counsel the matter of bail. Your Lordship, may I proceed with the matter of constitutionality?
Yeah, proceed.
Okay. Your Lordship, it is well settled that the Constitution of Georgetown is parametric to the Constitution of India, and that the Georgetown Religion Act is parametric to the Madhya Pradesh Freedom of Religion Act. It would be relevant, and it is important to note that the Madhya Pradesh Freedom of Religion Act is largely the same as the erstwhile anti-conversion.
I can't hear you, counsel. Move forward, because I can barely hear you.
Am I audible, Your Lordship?
You're very faint, counsel. I can barely hear you.
I'm really sorry for the inconvenience, Your Lordship.
No problem. Are you using some sort of a...
No, Your Lordship. I have logged in from 2 accounts, so may I keep the video on in this account and use another device to make my voice?
Sure. No problem.
Thank you, Lordship. Am I audible, Your Lordship?
Yeah.
What I was saying is that it would be relevant, and it is important to note that the Freedom of Religion Act, Madhya Pradesh Freedom of Religion Act, is largely the same as its erstwhile anti-convention law that was in force in Madhya Pradesh, namely the Madhya Pradesh Dharma Swatantrata Adhiniyam of 1968, barring a few differences with respect to the definitions and the prescription of punishment, Your Lordship. Notwithstanding these differences, the two anti-conversion laws of Madhya Pradesh are similar in their objective, which was to prevent.
Yes, but then again, counsel, just because the existing law.
The judicial pronouncements.
Counsel, can you hear me, counsel?
On the aspects of constitutionality of 1968.
Counsel, hold on. Can you hear me? I'm asking a question. When I am asking a question, please stop. All right.
Sorry.
Counsel, just because an existing law was in place which dealt in the same subject, that does not mean that that existing law was constitutional. It is presumed to be constitutional, but that doesn't mean it was constitutional valid.
Your Lordship,
you're aware of this principle, right?
Yes, Your Lordship. Your Lordship, in the judgment of the Stanislas versus State of Madhya Pradesh, the law was declared to be constitutional, Your Lordship.
Stanislaus versus State of Madhya Pradesh, it held that this Madhya Pradesh law was constitutionally valid.
Yes, Your Lordship.
And that was decided by the Supreme Court.
Yes, Your Lordship. By the 5 judgments. That is what I'm arguing, Your Lordship. May I proceed?
Yes, proceed.
Your Lordship. In the Stanislas judgment, the constitutionality of the anti-conversion laws, such as aforementioned of the Act of 1960, the Swatantrata Adhiniyam, and the Odisha Freedom of Religion Act 1967 was upheld on the ground that right to religious freedom as guaranteed under Article 25 does not include right to convert another person's religion, and that the acts were in fact promulgated to safeguard freedom of conscience as guaranteed under Article 25. Your Lordship, such judgment was of the 5-judge bench. Yes, at the face of this court, Your Lordship, which is seized of the issue of constitutionality of the Georgetown of Freedom of Religion Act. That is the impugned legislation, Your Lordship. The Stanislas.
And did the constitutional bench in that case uphold all the provisions of the act, or did they strike down any of the provisions of the act?
Yes, Your Lordship, it upholded on the ground that the right of right to religious freedom as guaranteed under
You
Article
just
20.
said that, counsel, but I'm asking a different question. I'm asking, did the court in the Stanislaus case uphold all provisions of the law, or did it strike down some provisions of the law?
Your Lordship, it upholded all the provisions of the law with regard to the Article 25 and the right to religious freedom that it guarantees. All the provisions, Your Lordship.
I'm not on that. You're not understanding my point. I'm asking a very simple question.
Yes, Your Lordship.
Did the court in Stanislaus strike down any of the provisions of the law?
Your Lordship, it upheld all the provisions of the law with regard to the Article 25. And
again, you're saying the same thing. I'm asking a different question, counsel. I'm asking, was there any provisions of the law struck down by the court in Stanislaus?
No, Your Lordship.
No.
Nothing as regard to the issue we are here concerned.
I am not again, I'm asking a very simple question. You answer yes or no.
No, Your
Was there
Lordship.
any provision of the law struck down in Stanislaus or not?
No, Your Lordship.
None of the provisions of the law was struck down in Stanislaus.
To my best knowledge, no, Your Lordship.
Proceed.
All right. So the Stanislaus decision is valid in respect of the Georgetown Freedom of Religion Act 2. The said act does not prohibit religious conversion by choice and free will.
Counsel, Georgetown's court is not bound by the judgments of the Indian court. You have to convince me separately, apart from Stanislaus, how this provision is constitutionally valid.
Yes, Your Lordship, I will come to that. I just want to put out one thing. Your Lordship, it was a coordinate bench judgment, and this is a 5-judge bench as well. So, Your Lordship, if a similar act, almost of the same nature, which is pari materia to the Madhya Pradesh.
Pari materia does not mean the same as.
Yes, Your Lordship, I mentioned it is similar.
Similar to, but not the same. We are not the same country. We are not the same court. We are not bound by the judgments of Indian court.
No, Your Lordship.
So that is the point. You are saying coordinate bench. It is not a coordinate bench. I mean, it is a coordinate bench, but it is not binding upon us, counsel.
Yes, Your Lordship.
Go on, proceed. I want to hear more. You can't just rely on Stanislaus's judgment and say that I am bound by that.
No, Your Lordship, no. Your Lordship, right to conversion necessarily connotes the right of an individual to renounce one religion and embrace another religion, or renunciation of the religion altogether, albeit voluntary. A person may give up his religion and adopt another religion for myriad of reasons. It may be a consequence of one's realization that the religion he was born into did not measure up to his expectations, even spiritually or rationally.
Whatever be the case, that point, it is well settled that you have a right to freely choose your religion.
Yes, Your Lordship.
The question is, does this law prevent you from freely choosing your religion?
No, Your Lordship. That is what
I'm arguing. Why do you say so?
Yes, sir. The aforementioned situations shall fall regarded as one of the essential ingredients of the freedom of conscience as guaranteed under Article 25 of the Constitution of Georgetown. Right to conversion must be viewed in contradistinction with the right to proselytize, Your Lordship.
I am not on that. I am saying right to freely choose your religion. Does this law give adequate safeguards to the right to freely choose your religion?
Yes, Your Lordship, it gives.
How do you say so? What provisions do that?
Your Lordship, may I refer the Constitutional Assembly debates as regard to the promulgation of the Article 25 of the Constitution.
Why? How is that relevant? I'm asking about this specific law. I am aware of the Article 25 Council. You don't need to educate me on Article 25. I am asking you with regard to this specific law, what are the safeguards to ensure that you can freely choose your religion?
Your Lordship.
Do you understand my question?
Yes, Your Lordship. I understand it.
Then answer it, please.
Yes, Your Lordship. We argue that no provision in this Act poses any restriction against interfaith marriages or prescribes disclosure of identity of interfaith couples intending to get married. No provision in this law prescribes to disclose the identity.
And why? What is the crucial? What is the need for disclosure of identity, Council?
Only prohibits, Your Lordship, it only prohibits marriage for the sole purpose of religious conversion. The Act prohibits forced conversion brought about by marriage, Your Lordship.
Yes, but that is anyway not allowed. Are you aware? Again, I'm asking you the same question. Are you aware of Sarla Mudgal versus Union of India?
Your Lordship, I haven't considered the judgment.
You haven't considered the judgment. Very good. Very good. Okay. I think your time is up. Let's proceed with your co-counsel. We'll proceed with your co-counsel. Just 1 second before your co-counsel begins. Just give me 2 minutes.
Your Lordship, I have just one point to make. Can I?
Your time is up, counsel.
Just one line, Your Lordship.
Yes, 1 line. Go. I'll give you 1 line.
Your Lordship, on a concluding note, I would express that the well-settled legal position that the fear of misuse of law that our counsels in opposition have repeatedly argued that the fear of misuse of a law cannot be a good ground for declaring a law unconstitutional, Lordship.
I was anyway agreeing with you on that statement, counsel. So fine. Thank you.
Thank you, Lordship. Much obliged.
Just 1 second, please. Okay. Counsel, co-counsel, proceed.
Lordship, would it please you if I go through the arguments summarized by my co-counsel?
I am aware of your co-counsel's arguments. You can proceed.
All right. So, with your permission, I would like to proceed with the arguments of bail on the bail application.
Yes, please proceed.
Yes, Your Lordship.
Proceed, counsel. We are waiting.
Lordship. So, Your Lordship, the first point that we would like this court to consider is that it may appear that the first of all, as your lordship already said, that a detailed examination of evidence is not required while presiding over an application of bail. And in this case, the High Court, after perusing the charge sheet and the FIR and considering the other materials on record, has decided that the bail should be rightly rejected. And in that case, and that is settled. And the counsel for the petitioner, they were harping on the fact that the accused has remained in custody for a lengthy period of time, for almost 2 months. However, we would like this court to consider that length of custody alone should not be viewed as a ground for granting bail, especially when the allegations are of a
counsel. Hear me out. Length of custody alone should not be the primary consideration. But the fact remains that a lengthy custodial period, lengthy period in custody should not is avoidable. It has been held in several instances that the court should not keep the person in jail for the duration of trial. It should be something that's to be avoided, right? What is the problem if this person is released on bail?
Lordship, the council completely agrees with your lordship that unnecessary detention is to be avoided. However, in this case, if we peruse the facts, we will find that the accused has displayed a violent conduct against the complainant, as well as because the complainant was wrongfully confined, and she was not allowed to contact her family members when she was under duress, and she was also threatened.
What if the court imposes condition? What if the court prevents this accused person from entering the home jurisdiction of the complainant? Then
lordship, then the counsel for the respondent would seek stringent conditions to be imposed on bail, and the accused be completely prevented from getting in touch with either the complainant or the family members of the complainant, because he has had a history of violence.
Achha, tell me something. So your main ground for opposing the bail is the fact of his violent conduct in the past. Is that so?
Lordship, the violent conduct as well as the gravity of the offense, your lordship, because with regard to gravity
of the offense, how grave is the offense? What is the maximum punishment under the law?
Lordship, if we look into section 3, if we look into section 5, which provides for the punishment to be imposed, then we would find that whoever contravenes the provision of section 3 shall be imprisoned with a term which may extend to 5 years. Now, your lordship, 5 years.
How is that a grave offense? It's not a life sentence or a death penalty at stake. So how are you making the case that it is a grave offense?
Lordship, you look into the third proviso. If you look into the third proviso to section 5, then it is stated that provided further that whoever intends to marry a person of any religion other than the religion professed by him conceals his religion in such manner that the other person whom he intends to marry believes that his religion is to be the one professed by him.
Proviso is applicable in case of this?
Yes, if we
Counsel, are you honestly telling me that the complainant in this case was completely unaware that the person she is marrying is of a different religion?
Your lordship, at this point in time, the evidence on court refute the content of the buyer. So we have to.
I am not going into the question of evidence, counsel. As a bail court, I cannot consider evidence at this stage. I am merely going on. Is it believable that the complainant did not know about the religion of the accused after being they had a pre-existing relationship before marriage? Did they? So is it believable? You tell me, counsel, is it believable that you are in a relationship with somebody and you do not know their religion prior to marriage?
Lordship, while it is true that it is difficult for us to accept this, that even after 4 months of being in contact with each other, they were not aware of each other's religion. But then I believe that I think the legislators had envisaged such a situation, because I think such a situation might occur, and it provides for a safeguard.
I am not convinced, counsel. I am not convinced. Why you cannot read? Why can you read into the intent of the legislature like this? Are you aware of the principles of going into intention of legislature?
Lordship, if we have if we are not able to properly if the literal interpretation is not unambiguous,
the interpretation here is very clear. How can we go into the the intention of the legislature here? This is not a situation where you can go into the intention of the legislature, counsel.
Lordship, apart from that, Lordship, we would also again ask this court, as we had the fear of tampering of witnesses, there is also fear of absconsion if the person absconds. So we would also like this court to impose.
Where is the likelihood of the person absconding?
Because if the third proviso to section 5 can be read into this matter, and if he's actually charged, then he's facing a 10-year imprisonment term. And there was this in a judgment of State of Rajasthan versus Balchand, Justice Krishna Iyer had stated that greater the severity of the punishment, there is a greater inducement to flee the course of justice.
But then again, have you charged him with this proviso? Has the charge sheet reflect such a charge?
Lordship, I cannot. I would like to seek instructions because I need to peruse the charge sheet myself.
Okay, fine, fair enough. Fair enough. All right. Anything else, Counsel? Anything else you wish to argue?
Nothing else, Your Lordship. Nothing else.
Okay, fair enough. All right.
Do we need to recite the prayer, Your Lordship, or is Your Lordship aware of it?
I'm aware of your prayers.
Right, Your Lordship. Thank you. Much obliged.
So Moot Court Committee, what I just have to give the marks now, and then do I have to do anything else?
Yes, so you have to mail the score sheet to
there is the rebuttal first. No?
Yeah, Your Lordship, we had taken 2 to 3
rebuttal
minutes
round, yes.
Kindly allow that.
So just one second, I'm just trying to get clear in the procedure, okay?
Sure.
All right. So we have a rebuttal. There is no sir rebuttal, right?
No, sir.
Thanks. Anyway.
So,
No, please, sir rebuttal goes on forever. Just before you start your rebuttal round, just give me 1 second, please.
Absolutely. Your Lordship.
1 second, give me a few seconds. I need to fill up the mark sheet.
Your Lordship, please.
Okay, rebuttal round.
Yeah, Your Lordship, we just like to proceed with 2 main rebuttals. The first is to the Stanislaus case, which was in 1968, and we think that what was essentially discussed in the Reverend Stanislaus case was the Madhya Pradesh Dharma Swatantrata Adhiyan, and that is something that is mentioned in section 17(1) of the Madhya Pradesh Freedom of Religion Act 2021, and it's repeat. So we do not think that the Reverend Stanislaus case is particularly applicable here, because we've noted the changes that the Freedom of Religion Act of 2021, like the changes and the differences that exist between the Act of 2021 and the Act of 1968, especially them being the transfer of the onus of like proving your innocence. The second being making fraudulent conversions a non-bailable offense. And we would like to argue that in the landmark case of Captain Jagjit Singh, it was like certain guidelines were laid down which highlight situations in a non-bailable offense where bail may be granted. Out of that, we would like to refer to a few of them. There were 13 that were essentially put. Out of that, we would like to refer to A and C, that's 1 and 3. That is the enormity of the charge and the severity of the punishment which the conviction will entail, because we do not think that the crime is that heinous, and it's also not something that you can practice very
I got
freely.
your point.
Conversion is not something that can be done very easily. Your Lordship, there are certain problems in our opinion with the respondent's case. That is, they base it on complete allegations, telling us that the petitioner is at the risk of absconding, that the petitioner has inflicted some sort of mental and physical torture on Mrs. Soumya. we do not think these stand because these are mere allegations and these cannot be
proved. These allegations cannot be discounted altogether, Consul. That's the thing, no?
Your Lordship, since the moot problem itself is silent about the charge sheet and the FIR, there is no way to confirm if these allegations stand true either. So we do not think that
there is no mention of physical or mental abuse.
It's just mentioned in the moot problem as an allegation that Mrs. Soumya does.
It's an allegation. So
yes,
the allegation is there. I am not a trial court that I will look into the veracity of the allegations. I merely have to look at the prima facie case, right? The prima facie case is made out.
Yes. We agree about that, Your Lordship, which is why we just want to contend one thing and plead this before you, that we are completely okay if our client is released on bail with the strictest of conditions to prevent any risk of absconding. Our petitioner
I've understood.
Police station once a week to give a signature.
It's perfectly good.
So if you can release it on the strictest of conditions, we'll be very, very much obliged, Your Lordship. So kindly consider very obliged to argue. Thank you.
Quit when you are ahead, Counsel. No.
Very sorry, sir.
Okay. Anyway, anything else remains, Courtmaster? We're done?
Yes.
And do I give the team's feedback?
Say if you wish to.
Yeah, just guys, as a general rule, all right. When you're in a moot court, no, don't come with speeches. Don't come with speeches. You will not be able to proceed with your speech. What I'm doing to you, trust me, every moot court judge will do. They will break your rhythm. They will break your pre-planned organization. Thing is, know your arguments, know your structure, but don't go by a script. All right. This is a mistake every mooter makes when in their early days. You need to learn from that and move on, right? Don't go by your script. Be very familiar with your arguments. In fact, I'll say that the petitioners, you all made a very crucial mistake. You all were not familiar with each other's arguments. You have to be familiar with your entire team's argument. Not that, oh, I'm not going to argue. I'm not going to talk about that in my speech. Therefore, I'm not going to bother. No, you need to know, because the point is, in every moot court competition, in case, for instance, your partner runs out of time, are you going to ignore that argument altogether? It might be the most crucial prong of your argument. So know your argument inside out. Your memorial should be absolutely at your fingertips. It is not important to cite n number of judgments. If you're citing one judgment, be very familiar with that judgment. If you're dealing with one concept of law, be extremely familiar with that concept of law. All right. That is the thing. More is not better. More, if you just because you're citing 10 judgments and the other side is citing 2 does not mean you win. It matters as to how you present that one thing. I have been in court in cases where my other side has come with a latina of judgments and I have come with nothing. But I have still won because my interpretation and my reasoning has been better. That is the thing. So don't go by volume. Quantity is not indicator of quality. All right. That is my main advice to you guys. But apart from that, both teams, you all are fantastic. You all are very good at what you've been doing. And honestly, I really hope to see you all in court in future years, because if this is what our future holds, we have a very bright future. Honestly speaking, I'm not kidding you guys. Very well done.